offences up to 50,000 without any imprisonment clause, but new offences up to 5 lakhs. New offences there is no problem. But I have found one peculiar situation, especially for the not conducting of AGM within the time frame. Offence is under the new act, but the penalty under old act. Because section 99, which speaks about the penalty for non-holding the general meeting or AGM, came into force only 1st June 2016. That means the corresponding provision, that is a 159 I believe, 168 was alive still 1st June 2000, or means 31st May 2016. So offence committed under new act because of the AGM, I am supposed to conduct AGM as a new act, but there is no corresponding penal provision in the new act which not came into force. So here my situation also same there. Then I requested the NCLT bench Bangalore. They have in fact agreed to levy the penalty as per old act only. Because 99 came into force only right now. 99 as per my understanding will be applicable for AGMs conducted in 2016 onwards. This is the one difficulty, sir, I think. And as per the regional directors is concerned, we do not have much problem because we are able to convince the ROC as well while forwarding the application to the regional director office, and that regional director office also, because it is like a one-to-one discussion and enough time is given to make them to understand. They are also not guided by any rule. Today we have NCLT. Even I think last week there was a judgment by the NCLT LAT. They say that there should be standardization in imposing the compounding fees. They say 1/5 of the so and so penalty what is mentioned in the section or fine mentioned in the section can be imposed. Not like in one case 20 lakhs was imposed for a small, like same AGM was not conducted so many years. That per day penalty was there as per old act 2,500, as per new act 5,000. They took the 5,000 case and imposed the 20 lakhs as a penalty for so many days delay. And they went for appeal. LAT said that you need to be reasonable. You have to see the facts. And even if I would like to draw the attention of the 2016 amendment proposed bill also, they say based on the size of the company, based on the so and so, if it is a small company, you have to be very lenient in imposing the compounding fees like that, because it is, after all, it is a compromise. I am admitting that I made a mistake. So these are the cases, sir. Thank you very much to giving opportunity to us. We will certainly come with the detailed note, and tomorrow we will be submitting to the moot court. Thank you, sir. Thank you.
Thank you, team, for giving us a highlight, I think, which can sensitize to the regional director, sir, also, what type of work we have done in past 1.5 days, and remaining time will be concluding and then submitting the paper with the CCGRT. Now I'll request Chaturvedi sir to brief us, guide us and mentor us for further movement in the process of this workshop.
A very good afternoon. So indeed, it is a great day for me to see this huge complex, because I always compare with your headquarters at Lodi Road, where I was going frequently to do some statutory work there. Your election tribunal works from there. So recently I had opportunity to had so many hearings, including Western region professional also. So I can see you have competitiveness in every area, including your election body. So that's a good thing. Any institutions rise only when members takes the interest. So here is also another thing specifically which is mentioned before me. all across the country, it is a mixed blend of young professionals and researchers, those who are working, and I am happy to see that you are very minutely analyzing the actions of regulators and quasi-judiciary or forums. Indeed, for research work, I hope it should not invite any legal complication by the court of law, because when you are there are certain judicial principles, because I am from legal field, so let me clarify your position. What is the Constitution says? Any criticism or analysis of judgment, even for research work, one must understand that never quote the citation of the case. You have to hide certain identity. This fact you must notice while preparing your any research paper, unless until you have taken permission from that judge itself, because normally what we feel, judgment is by the forum, but judgment is proprietorship of that judge who has delivered it. Indeed, it is his judgment. That's why it is called judgment. It is like an article. You write article, and judgment is analysis of facts and resolution of issues within the legal framework. Why it has been made in jurisprudence? So that one autonomy should not encroach another institution autonomy. So there we have to strike the balance. Another thing, we were discussing the law of compounding. So I have experience of both criminal law as well as corporate law and other laws. So what is the compounding? See, under Code of Criminal Procedure, thank you. Under Code of Criminal Procedure, why compounding has been brought? Because what is the duty of the state? To minimize the litigation in the court of law, and also to create harmony between the prosecution, prosecutrix and accused. Because ultimate aim is to satisfy the complainant, redress his grievance. Otherwise what will happen? If complainant is not satisfied, he will continue to initiate further legal proceedings. So that's why this compounding is brought into the Code of Criminal Procedure. And Code of Criminal Procedure, we must understand that it is the procedural law initially enacted by Lord Macaulay in British period. What CRPC we have today, it is a 1973 based upon G.D. Khosla committee report and other committees report, and Law Commission. Law Commission is a one researcher body, like you have created CGRT, CCGRT. Law Commission is an independent body, work within the Ministry of Law, which gives suggestions to the government for enacting some good laws, either on repealing or amending or whatever, which is headed by normally a retired, not less than Chief Justice of some High Court or Judge of the Supreme Court. They sits in New Delhi, and many times they throw the paper and invite suggestions from common man. When I say common man, means public at large. Recently you must have heard about Law Commission suggestion on this 3 talaq they have invited, and lot of things were conveyed in media and other places, but that was not the idea. Law Commission is not the law making body, but indeed it was a process to take the views of the aggrieved or stakeholders, whatever you call it. So in criminal law, law of compounding is based upon 2 major principles. One, it is not applicable in a grievous nature of offenses, we must understand. Law of crime says there are two kind of rights available to a person. A crime can be happened with anyone, and anyone can commit also, knowingly or unknowingly, with intention, without intention. But our law of crime believe in crime with always intention, motive, and preparation, etc. That is inbuilt in our law. So there is no excuse for it कि I don't know the law. So what I say, right in persona and right in rem. When right in persona is there, person has right to compound it with the accused. While in right in rem, state has made certain norms कि what kind of offences can be compounded, what cannot be compounded. Like in our, there is a theft. So theft can be for a small amount also and large amount also. So our CRPC has permitted for like if theft is for 250 rupees property in earlier days, still it is in the force, one has right to compound. Then with the permission of the court. Similarly, there are in CRPC schedule is there. Section 320 is the operating section which provide the procedure. Their word is written, prosecutor. No offense can be compounded without permission of the prosecutor. So, not only accused, but also permission of the prosecution or consent is required. While in Companies Act, there is a different motive. That's why it is written word notwithstanding anything contained in CRPC. I am answering to your query. So we must draw the line between offences compoundable under criminal law and Companies Act. Why this difference has been made? Ki every offence is compoundable, what you are reading. Because as I said, companies is a special purpose vehicle. It itself is not a business. Companies is a modus to do some business or some activity. Maybe charitable, maybe for profit. That is the concept of the Companies Act. So while performing the companies, there are certain legal obligations for which who runs the company? Company is a legal person, but it is always represented by some person. So for that reason in CRPC also there is a specific section 306 or 305, you read it. Company cannot be represented unmanned. So those persons are responsible who have been authorized to do some act or not to do under the authority of the board and MOA. MOA is the guiding principle. So if or under Companies Act, if certain returns are to be filed, not to file, whatever. So those are the things provided in the law itself. So any offense which is defined under Companies Act, it is compoundable because of the reason. I think majority of the offenses are non-cognizable. First thing, complaint based. Except I think one earlier section was amended, like for public deposits, that has been made, for prospectus, that has been made cognizable. Because of some scams taken place, then amendment was brought in. So this is the technical difference between a company act compounding and criminal law compounding. Because company itself is not made for doing some crime. These are the person who are at the helm of the affairs. Because of their negligence or due to default, company becomes defaulter. So that's why offenses have been made compoundable, so that company record should not be blemished. And that's why concept of made good default has been brought in. Ki before compounding, you must make good in default, so that company record is clean as per registrar portal. So this is the difference. While in criminal law, no such requirement is there. If somebody has committed theft, while compounding he should return the money. That is not written there. Because there is a criminal mens area. There is an option available to the complainant. But not for offences of serious nature, say 2 years or more, or say in crude word 10 years or more. There are certain offences which are punishable up to 7 years also, like cheating, fraud, that you cannot compound. This is a difference. Another thing, you were asking about the amount of compounding fee. We must understand law of crime is based upon time is the factor. When offense was committed, because no criminal law can be made retrospectively in force without the parliament. Parliament can make. But normally our constitution says that law should be there when offense was committed. In law, if law is not there, you can't create law subsequently. Suppose something you are doing, today there is no law violating those things. Tomorrow Parliament passes law and then they say that oh, X will be prosecuted. Then court of law means High Court, and Constitution Court like Supreme Court, High Court will struck down those provisions. That's why no criminal law is ever made retrospectively if in force. So when offense is committed, if there was some penalty, then compounding authority has to impose that penalty only. They cannot impose new penalty. They can't, because when offense was committed, penalty was not there. It is like that. So, but compounding certainly can be under new law, because 621 has been repealed now. 441 or 442, whatever section is there, one has to apply that because it is a procedure law. You are coming for compounding and compounding can be done. Similarly, for you are saying about talking about compounding fee, he has imposed 20 lakhs or like that. Every authority has to keep in mind. I always tell even to my field offices, many times adjudication power is now vested with registrar of companies. Many appeals I heard under 454 where penalty has been imposed to the extent of 4 lakhs, 5 lakhs, though company share capital was 1 lakh. So as an appellate authority, I have to pass the remarks on those appeals, because adjudicating authority is going to kill the company, while company is made to do the business. That is not the objective of the law. So I have affected and revised those orders. I am not mentioning those orders here because that is not proper for me. But what I say, adjudicating authority as well as appellate authority has to keep in mind the size of the company, irrespective whether government guidelines are there or not. Court of law also consider those things while imposing penalty. It is not the case if somebody has committed theft for a bread or some for small things and he will be punished for 3 years. Not like that. Court also many times gives till rising court, or sometime admonish also. Admonish, you must be knowing what? Admonish means in court record it is called conviction, in the sense if he will repeat the same offense, that time including previous one he will be convicted. It is like that. Under the court of CRPC, these kind of powers vested with the judicial court. So indeed your this, now I am coming to main topic of your Gita sir. Your CCGRT has undertaken a very good initiative. I am quite sure that it will help not only the younger generation but also to the professionals and adjudicator to know the reasons and analysis of the act of the regulator or quasi-judicial body while interpreting the issues pending before them. And I am really happy up to, I think, the section you have taken volume 1. I hope you should complete as early as possible for remaining section also. So, because why younger generation should refer to Ramaiya. Now, Ramaiya, as we know, there is no Ramaiya now. It is revised by different professionals now. Mr. Ramaiya, when it's written, that time old Companies Act was there. After that, so many Companies Act have come, 56, now 2013. So that is another area. So this is in fact in legal field also, many law students are doing this kind of research. Nowadays, if you will go to High Court and Supreme Court, there is a 4 or 5 legal researcher designation you will find. Who are those? They are students from law schools. They come for internship for say 1 month or 2 months. They help the judges taking out decided cases, references worldwide. Because it is going to value added to younger generation also. When you will come into the profession full-fledged, you will have, these are your tools. You will be in better effective before any forum. It will give you moral confidence as well as your internal confidence. You know your subject, facts may be different. See, in law, it is normally called